What's up, everybody? Welcome into another episode of The Lawyer You Know. And we have a little hearing to talk about today that some of you may have been discussing on Twitter/X, and that's Karen Reed's hearing. And a lot of things went on in the hearing. There were motions to compel, there were motions for reciprocal discovery, there were motions for metadata. All sorts of things came out. But what everybody's talking about is when Judge Cannoni, at the end of the hearing, stopped the show, left, comes back obviously upset from what Hank Brennan just shared with the court, and suspended the hearing. Says we're going to pick this back up next week when everybody has an opportunity to go do their research and come and discuss exactly what's going on here. It has kind of a loom of something major may happen, and it does not seem good for Karen Reed. Something majorly bad could happen to her, either defense expert or defense team on the lawyer side. And what we're going to do is we're going to watch exactly what Hank Brennan said. We're going to talk about how big of a deal it is and what the potential sanctions could be if what is being purported out in open court is true, because we didn't get to hear from the defense. We're going to start with that, and then we're going to get to the rest of the hearing as time allows. So hit that like button because we're getting to it now. All right. So everybody just take a deep breath. Everybody take a deep breath. There's a lot going on Twitter right now, and everybody's like, oh, he's going to make an excuse for them here, or, oh, this is a nothing burger. Hank Brennan's just lying. And I think, as is often the case, the truth is probably somewhere in the middle. But the most important takeaway from this is going to be there's still a lot we don't know. For example, what is in the actual documents Hank Brennan is referencing? He didn't read them in open court. Some of them is probably protected, but I think it's important to remember we haven't even actually read those documents yet as we go through it. But this was at the end of the hearing. I don't think it was supposed to be the end of the hearing. And what we're going to start with is Hank Brennan's recitation of why we cannot trust these defense lawyers, which is what he opened up with on his very first argument, is it's just like the defense to either misrepresent the truth or talk about half of the truth and leave out the other. I can't even have undocumented conversations with them anymore, Hank Brennan says. And so this was a continuation of that. So let's listen to his argument for the court that he has a bombshell, a smoking gun to show how unethical the defense is, and that they're trying to ambush the Commonwealth again in this trial, just like they did in the first trial.
Your Honor, my purpose is not to deprive the defense of an expert, or deprive the defense of an ARCA expert in this case. But there has to be...
He corrected himself because he's like, I was trying to cut Russell and I'm still trying to cut Green. And he did technically try to exclude ARCA, but he said there's discovery violation, so it is a little different.
A minimum requirement of reciprocal discovery and discovery before a party can call a witness. It's not enough to say that the witness is helpful or unhelpful. There has to be full disclosure when calling an expert. It's interesting that the defense's position is that the information is unavailable to them, and that since there's been a voir dire and trial testimony, that should be enough. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other and that expert witness that they don't know about and can't ask about, that there's some type of bias or favoritism that the expert might have towards one side for whatever reason. So if that information is not disclosed, then it is not only an impediment, it creates a position where it is an unfair examination.
I agree with all that. No, when you talk about bias or witnesses getting something from the other side, it just means payment, right? Yeah, I hired you, cost $5,000, whatever. And so you can argue to the jury, hey, he's paid to give the opinion that's going to help the side. Both sides have experts. Totally normal what he's saying as far as showing bias or some kind of reason to testify a certain way for the defense.
It's not the ARCA witnesses that I have the issue with. It's the fact that I don't have adequate discovery. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. Now, I wasn't at the last trial, but I've read the transcripts. And on June 10, 2024, you asked the defense about ARCA, and it was represented these experts were hired by the federal government, and they provided a report to us pursuant to a TUI request.
Okay, so something that's going to be really important to our discussion is the timeline, the dates. Okay, June 10th. So this was during the trial, but before the voir dire of the ARCA witnesses and before obviously the actual trial testimony of the ARCA witnesses.
It was specifically outlined and ruled that they could not prep with us for trial. Could not prep with us for trial.
It was specifically outlined in the rule. I don't know what that means. As you guys know, I was not privy to everything that happened pre-trial, but I want to listen to that again because he said was specifically outlined in the rule.
The federal government, and they provided a report to us pursuant to a TUI request. It was specifically outlined and ruled that they could not prep with us for trial.
It was specifically outlined in rule. I don't know what that means. I don't know if it's a court order. I don't know if it's a federal thing. I don't know what he means by in rule. So that's one thing. That makes a big difference. If this is a court order, if it's a Massachusetts rule that you're not allowed to prepare with these witnesses for whatever reason, that's really important. I would like more clarification on what he means by in rule.
Could not prep with us for trial. And so Your Honor said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. The answer, that's essentially it. We've spoken to them only for purposes of coordinating their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. Your Honor said, see, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify. And you have not complied with your Rule 14 obligations. And the defense says, we can't, Your Honor. And Your Honor said, so you can't, but you haven't. So I'm left with that you have not complied.
So, okay, that is June 10th. It's important. So what did they say? They haven't prepped with them. They have the report just like we do. We've only talked to them for scheduling and purposes like that on June 10th. Because if lawyers are lying to the court, okay, if lawyers are just flat out lying, that's a problem. You can lose your bar license, you can get sanctioned, you can get thrown off the case. We're going to talk about what some of those sanctions could potentially be. But if what they're saying at the time is true, that makes a big difference, even if it changes later, right?
Where in the transcript is this?
On page 2812 and 2813 of June 10th, 2024. Now, having some familiarity with the federal government, it seemed to me, based on my limited experience, there was much more to the story. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. And it was striking that it wasn't noted as unresponsive. Just when I read the materials, and Attorney McLaughlin actually identified them, they didn't respond to our request. So Attorney McLaughlin wrote back, and then we got new materials, just some. But these materials are the very reason why the defense should not be able to call witnesses without giving full discovery.
It's also important. I think there was a motion for sanctions too. I haven't read that, but this was a discovery violation to strike ARCA and not be able to call ARCA. I don't believe, I could be wrong, that Hank Brennan asked to remove Alan Jackson from the defense team as a sanction here. So we might as well get into it. Okay. There are different things you can do as sanctions if there's a discovery violation. Number one, you can not allow them to testify at all. You can strike the witness. Number two, if there are some kind of undisclosed expert opinions, you can strike certain opinions and not other. Number three, you can make the other side turn over additional discovery prior to that witness being able to testify. Number four, you can force another voir dire so they can get all the information, kind of like what happened in that case, in this trial, what happened in the Sarah Boone trial. And then if the lawyer committed these violations and lied to the court, you can sanction the lawyer by making them pay a fine. You can remove them from the defense team. That would be an extreme sanction because of the obvious prejudice to the defendant. And that's something we have to remember, right? We talked about so much listening to the juror interview, how the deck is stacked against every defendant, not just Karen Reed. And removing her lead defense counsel would be such an extreme sanction. I would be shocked if the judge did that and if it was upheld by higher courts. Now, the only thing that could potentially be working against Karen Karen Reed, which it's really interesting because we got kind of this argument from Hank Brennan today when we talked about whether or not Bederow should be able to be allowed to come in pro hoc vice, which we'll watch that later, even though it happened earlier in the hearing. She has a bunch of very good defense lawyers on her team, so maybe they would argue, oh, she'll be fine with the team she has. It's not really how it's supposed to work. Hank Brennan even agrees that's not how it's supposed to work. Criminal defendants should be allowed to choose their defense attorneys, but those are the potential sanctions floating out there in this, looming dark cloud that was felt when Judge Cannoni came back. These are potential sanctions. I would be shocked personally if that's what happened, unless more details come out, which we'll talk about what details can be really important.
Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but the ARCA witnesses themselves. A recent request for their appearance pursuant to TUI, which I have no issue with. But if we look back earlier in the relationship, what we see back in March 22nd, 2024.
Right. March 22nd. I think that's prior to the first trial date. And it's definitely prior to June 10th, right? When he said they haven't really talked about anything but scheduling. So it's prior to all those comments being made. This is in March of 2024, March 22nd.
Is that there are conversations between the defense, Attorney Jackson, and Daniel Wolf, who's one of these ARCA witnesses. Thank you so much for taking the time to get on the phone with me this morning pursuant to our conversation. Please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer as required. The Commonwealth, as I understand it, was not aware of any promised rewards or inducements or payment.
So that sounds bad at first, right? Hey, send me in and get a retainer agreement and I'll send you your money in March. Sounds bad. I didn't think that happened. But wait, there's more, at least with where it comes from the March. And everybody, again, like I said, take a deep breath. We're going to talk about Jackson's comments afterwards. We're going to talk about what's being reported out of the courtroom. We're going to look back at the first trial testimony to see what the ARCA witness actually testified to, what questions Jackson asked him. Words are really important. The timing the words are said are really important. Okay. But he asked for a retainer agreement. Now, there's nothing more than that in the email. At least we're hearing Hank Brennan read it. So it's a situation now where Jackson said, hey, we want to hire you guys. Send us a retainer. We'll send you your money in March.
They relied on a reciprocal discovery order of this court for that information. Response, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked we pause any further conversation until we received additional information from their office regarding how our involvement will move forward.
So they respond and they say, hey, feds say we got to pause everything, which is exactly what happened. And there you go. So not a huge deal there with the March conversation. The only thing I will say is the defense probably would say that, well, you can infer from that conversation they had on the phone that it was more than just scheduling if he wanted to send his retainer. Just like they said with Proctor, he said he didn't want to watch the closing. Well, you can infer he watched other parts of the trial. So I do think potentially the defense may say that you can infer they had more conversations, but the fact is that's kind of why lawyers have conversations with experts on the phone and not in writing, because it's discoverable. Now, you don't lie about your conversations, but it's not as detailed, obviously, as if it's in writing.
Now, it's not the opinion that troubles me. It's the relationship, and Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my... Alan, I spent some time... Saturday, June 20th, tells me it's the relationship.
I want to make sure I got the dates right. They're important. So this one is from Saturday, June 22nd, 2024. This is, I believe, post voir dire, pre-actual trial testimony. So this is when they came and testified in court for the judge to say, okay, can they testify or not? And for Lally to ask any questions so that we don't have any discovery issues. So this is after that voir dire, but prior to their trial testimony.
Commonwealth should have an even playing field. Saturday, June 22nd, Daniel Wolf writes, Alan, I spent some time this morning putting together a brief outline of my qualifications, also attached my D&T list. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary.
Okay. So here comes the section that I really wish, if any of you guys see this, maybe I haven't seen it yet. If any of you see that document anywhere, I don't think we will, right? I think that stuff probably is not going to get released. But if we can find the document that shows exactly what Wolf sent to Jackson, that is important. Did he send an outline of all of his opinions? Hey, ask me this, ask me that. Did he send specific questions? How much detail was in there? Or was it just one or two lines and something that's no big deal? Because it matters. Prejudice matters in discovery violations. Prejudice is sometimes the only thing that matters, because if we can cure a problem simply, then we will just do it. We're not going to throw lawyers off a case. We're not going to delay a case. We're not going to turn everything upside down and waste more time and money for the taxpayers. We're not going to do that if it's something simple and not prejudicial. So I really want to know what's in that document or email that Wolf sent to Jackson on June 22nd. But what I will say is, it sounds to me like that is absolutely discoverable. And Jackson and team should have turned it over to the Commonwealth. And if they didn't turn it over at trial with a lot of things going on, they should have turned it over during the discovery time before the second trial. Now, some people can say the discovery is still open for the defense. And Hank Brennan said all of this came from the feds. He ends up correcting himself. That's absolutely wrong. And that's a big deal. If the defense was trying to hide this forever and the feds turned it over, oh wait, that's happened in this case before, right? Not the defense, but no, I'm just kidding. But when we have a situation where if the defense is trying to hide something and lies to the court and lies to the prosecutor and the feds turn something over, that in it of itself is an absolutely huge problem. But the correction, and did he lie or did he misstate it? I'm going to give him the benefit of the doubt, which is going to piss people off. I get it. I'm going to assume it was a misstatement because he immediately, when Judge Cannone comes back, he corrects the record and said, actually, the defense said it. Okay? So it's a huge deal that, in fact, the defense turned this over within the discovery period. So it's late discovery. If anything, it's not turned over discovery. Okay? So let's make sure we correct the record here. And there's no prejudice, basically. They're still turning things over. You have this now. We're turning over what's going on with ARCA and everything we have with ARCA. Okay? So far, what we've seen, what we've heard is not something that's going to just nuke this case. Unless they lied or said something in this email and said something opposite in the trial testimony, which is why we're going to watch it. What did they represent to the jury about their conversations and their relationship between the defense and ARCA when they were on the stand in front of the jury, which is really all that matters at this point, what they did the last trial, what they're going to do at this trial.
Now, this isn't information provided by the defense in municipal discovery. This is information provided by the federal government after numerous requests, 2 requests, and an insistent, the best I can, to get as much information as I can.
That's what he said. This is not something turned over by the defense. This is something we had to get from the federal government. And I truly believe with all my mind that Hank Brennan thought that was true. I truly believe he thought that was true. I think he thought he had a smoking gun. I think he thought he was going to blow these doors off right now. And I think he went back and sat down with a smile on his face when Judge Cannone shut it down and walked away to go do whatever she was going to do before she came back. And somebody told him, maybe somebody on the defense team, maybe one of his other prosecutors working with him. And he was like, oh crap, I better protect the record. Because I know people hate Hank Brennan. People hate Alan Jackson. I don't think either of them are purposely lying to the court. That's just my opinion. I know people are going to say it was a lie. I know people are going to say it was intentional. If it was, then why did he correct it immediately when Judge Cannone came back? Was he doing it for the cameras? Was he doing it for the show? Okay, I guess. That's just my position is I really think he believed it to be true, and he sat down and probably swallowed his heart. That's my guess. That's my guess. But it still could matter. Okay, it still could matter even if it was turned over by the defense. Rebecca said, can the pretrial motions be an appellate issue later down the line? Yes, some of them absolutely can be. Zezalek said, but didn't they all know what the opinions of ARCA was? So here's the thing, and that's where prejudice comes in. Discovery violation. Was it intentional, and what prejudice did it cause to the other side? If it was intentional, that's bad, and that could have some lawyer misconduct on it, which is still a question that's open for us right now. We're still gaining more information. But was it prejudicial? It just is not prejudicial. And that's what your question goes to. I really don't think it's prejudicial. Like what I talked about with my dad on the podcast yesterday, it seems like it was 100 days ago since so much has happened since then. But he's like, you got to voir dire him. You've got his first trial testimony. You could voir dire him again if you want. The judge will probably let you do that. You have a report. Like, what else do you need for an expert? But if lawyers put conversations with experts in writing, usually I'll say, and I'll say for my jurisdictions, usually that is admissible, and we all know it. We all know it. If you're telling them what to say or telling them what questions are coming, usually we're allowed to bring that out in front of the jury. Talk about witness preparation.
We then are provided an outline of questions and answers for a direct examination. The Commonwealth did not have the luxury, the privilege, did not even know that there was an outline that was being disseminated by this totally independent witness who took.
So he did not know there was an outline being provided. I want to know what's in that outline, right? We're getting little crumbles or crumbs about what exactly was provided. Some context, some outlines. Here's how I'll respond to your questions, things like that. And it's important to also note, this is not Alan Jackson, at least it doesn't seem, again, because we haven't seen the document. It doesn't seem like Alan Jackson sent this witness specific questions, right? It definitely does not seem like that by how Hank Brennan is discussing this again before his first trial testimony.
No side other than that of the truth. What follows from this outline is then the outline with remarks from this independent expert who knows nobody.
So there's an outline and then an outline with remarks. I don't know, was Jackson sending him an outline? I really can't tell what was in the email. You guys let me know. But there was some outline with remarks. So then the expert adds remarks. Does he add remarks to his own outline? Did Jackson send him an outline? I don't know the answer. I don't know the answer.
So we see in the margins in the notes, this fair-minded objective witness says, so not being able to inspect the vehicle is something that is not uncommon in your line of work. And he writes, absolutely not. And then he comments, not sure if you want to put this somewhere in the direct examination. I have a feeling they, the Commonwealth, are going to argue. I didn't personally inspect the vehicle. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case.
What's the date of that?
Okay, so there's definitely some lines from Alan Jackson. But, okay, and this is where people are going to be mad. People are going to be mad. Words are important. Lawyers use words for a living. But he said, is this something you do normally? Like, do you actually always have to review? Is that important? Whatever it was, some like kind of vague question. And the expert responds with comments. And here's what the Commonwealth's going to argue, et cetera, et cetera. So again, I cannot state this enough. This all to me seems to be very much discoverable, and they should have discovered it. Now, again, when we're talking about prejudice to trial number 2, there is no prejudice for this late discovery from the defense because he has this information. He can ask the witness about it during trial number 2. So from my perspective, I don't see a shred of prejudice to this information being turned over to the Commonwealth.
It's not dated. It's not dated. The TUI request is a recent February response, but they send random documents. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA.
He keeps saying that. ARCA could be correct still. I don't care. ARCA can testify. They can say what they want to say. Gray space, it could be, and that's the annoying thing is I do wish I had that because that's incredibly important to me is what exactly is in the outline. What's in the box, as they say. But we'll see.
I'm not saying they're not qualified witnesses, but it certainly shows some bias. I've turned over a lot less in this case than this.
And you've also not turned over a lot, right? And you're still talking about earlier in the hearing, if we get to it, depending on how much time we have, turning over stuff about the Sallyport video and, oh, it's this guy saved it here. It's no big deal. He saved, but none of that was turned over, which again, I think is bad. I think is horrible. I think they should turn it over, but maybe I haven't seen every discovery violation in the same exact vein, but when the Commonwealth doesn't do it, it's so much worse than when the defense doesn't do it. And the fact that he's lighting this match, acting like he's taking the whole ship down, and how Judge Cannoni acted, when this is what it is, at the end of the day, we have to actually look at what it is. And there's two things here. What's actually in the email and the outline, and is that prejudicial? Is that big of a deal? To me, the answer is no. Did Alan Jackson or this expert lie in open court or to the court? A very big deal that remains an open question at this point.
Another comment. Would it be fair to say because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Yes.
That sounds kind of like a specific question. I don't know if we're going to parse this out, but are these specific questions? Are they not? Words are important. You guys can decide whether you think these are specific questions or not.
Work, your cases frequently involve pedestrians. Yes, unfortunately, there is a direct correlation between the time of day and pedestrian fatalities. Statistically speaking, most pedestrian fatalities occur during the evening and night hours. That would have been nice to have. So my specialty in the area.
So he says that would have been nice to have. Okay, just pause. Everybody settle down. He says, oh, more accidents happen in the evening time. Like, duh, first off. Second, that would have been nice to have, he says.
Of lighting and human factors results in a lot of my cases involving pedestrians. Pretty important stuff in this case. And then he comments, if you don't want me to say this, that's fine. That's fine. Shh. Don't tell them.
Okay. Now, here's what I'll say. This stuff, I do think the reason it's important is, oh, you don't work for the defense. You're these unbiased third-party experts. You don't care about the outcome in this case. Then why are you writing things in emails like, if you don't want me to tell them, shh, I won't. That's bias. He can ask the question that. He can absolutely ask that question to these experts. However, let's take a look real quick at the testimony from day 30 of trial. This is the expert wolf in the wild, I almost said, but this is his testimony. And guess what? In trial number 1, the statements that Hank Brennan said he wishes or would have been nice to have, shh, don't tell the Commonwealth. He said it. He said it. Lally could have dove into it and made a big deal about it if he wanted to. He said it. So again, no prejudice so far. So here we go.
Would you say involved pedestrians as well?
Several hundred. As I mentioned earlier, a great, excuse me, a great deal of my work is in the field of lighting and visibility. So there's a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework.
First off, you don't need to tell me that. I don't need an expert for that, first off, because everybody knows that. So again, is this prejudicial if he didn't say it? No, because everybody knows there are more pedestrian accidents at night. But to have the statistics behind it, I think is important. And he said it. And he said it. Okay? That's just the first clip from the other trial. There will be more. Let's get back to Brennan's argument.
Have you qualified as an expert in court before? Yes. I realized my testimony, I said it 20 times. When you asked how many I've been qualified, I misinterpreted the question. My fault. 11 trials, 7 depositions. Not sure if you want me to clear that up. I don't know if it was ever cleared up.
I don't know if it was ever cleared up. Well, you should know. If you're going to make this argument, you should know. By the way, if anybody's counting, 11 plus 7 is 18, and he said 20. Like, is that prejudicial? A, no. But B, remember that, right? Let's remember that for when because we're going to listen to Alan Jackson discuss the background. Actually, I don't know if I kept it all in there, so I'll spoiler alert. I think it is going to be in the next clip we watch, but he doesn't actually say a specific number. Yes, you've been tendered as an expert before is basically the question that he asks Dr. Wolf, and he says yes. So he did not say 20 at trial. So was it corrected? Yes. What he said at voir dire, 20 versus 18, I will just tell you, we can make a big deal about that if you want to. I just don't think it would be genuine. I don't think that's a genuine big deal. If you lie to the court, it's a big deal. There is something I do think could be potentially a really, really big deal that some people are brushing under the rug that I am not going to, and people might not be happy about it. But I'm just going to be honest with you with how I look at things.
And then a bill from ARCA to the defense for $23,925.
Okay. And I didn't realize that was just what a perfect transition that was. But a bill from ARCA to the defense for $23,000. I did not hear a date on that bill, so that would be important. My dad and I discussed it at length, who had to pay for them to come testify. A bill is not the same as a payment. I don't know if they paid, but I have to give all these qualifiers because I'm not just going to spout off. Okay. I'm going to put if this, then this. It all depends. That's how lawyers answer questions. Sorry. So if that $23,000 bill was in fact paid by the defense for ARCA's testimony in trial 1, to me, that is a big deal. Yes, I know that after I have not seen the interview with Alan Jackson. I've seen notes from it and tweets from it. And Alan Jackson said that they did not pay ARCA for their testimony, something to that effect. He said it a million times. That's been one of the shticks. That's been one of the big deals about the defense. We are also going to watch exactly how that exchange went in trial number 1. Now, I have heard people say, no big deal. He's talking about expert fees. That was just travel and expenses. Okay? Expenses, travel, etc. If they paid expenses, travel, etc., I still think this is a major problem for Alan Jackson and the defense. Because even if you just pay expenses, travel, etc., that is still something that should be disclosed and should be allowed to be asked, especially when it's $23,000, because I can make that sound like a very big number at trial. They paid $23,000 just for your travel and expenses. Did you travel first class? Were you put up in a suite at the hotel? That's exactly the type of questions that were asked to the Rocky witnesses that weren't experts, but he flew somebody from Paris, I think, on a lay down first class, business class, whatever, and put him up in a suite. If it really is $23,000 for travel and expenses that should have been disclosed, that is fair game to ask a witness that. And to say we have paid you nothing, again, words are incredibly important to me. Stephanie, isn't common sense that they would pay for their travel? Yes, that's why I kept saying how shocking it was. Go listen to the podcast I did with my dad. The whole time we were like, gosh, they didn't pay him anything. My dad's like, they had to pay him. That's what my dad kept saying. They had to pay him. The federal government paid him. Now, is this going to be a bill that was paid by the federal government? Well, then that's egg on Hank Brennan's face. Okay? But from my perspective, if you say you didn't pay him and that was such a big deal, and you actually did pay him $23,000, I just would be surprised. I would be surprised if this happened, honestly. So let's take a second now, and we're going to hop over and listen to the exchange, and we're going to try to remember what Hank Brennan said from those emails about Jackson's interactions with ARCA and payment, okay? Because that's a lot of what was here. And make no mistake about it, we all know, and myself included, this was such a big deal that the feds hired and paid these experts. The defense didn't even have to do it. And there you go. People are saying paid for travel twice. I don't really care. If it was $23,000, that's fine. That can be very legitimate travel expenses. You still have to disclose it. You still have to disclose it. And I don't think Jackson left a lot of room for gray area when it came to payment. Now, he did absolutely leave room for pay or for gray area in their discussions prior. So these are two things we're going to really listen for in this 5-minute clip here. $26,000 paid by DOJ. Okay, again, I don't know. I don't know the answer. All right, so let's take a listen to this exchange between Jackson and the witness. It's really interesting how the chat just goes off the rails when maybe we disagree on one point. We may agree on one, we disagree on one, and you're the biggest idiot in the world. I can't believe you do this. You must be on the books for one side or the other. It's like, okay, if you think so, but this is literally what I deal with. I have to disclose payments to experts all the time. And guess what? I don't just disclose the expert fees.
You are unmuted.
By the way, just to confirm and tell you, Alan Jackson also doesn't just disclose expert fees when he talks about an expert. When they asked for reimbursement for what was paid for the expert, did they include travel expenses? For what they had to pay the expert that flew over to copy the video that wasn't there? Remember that? You guys remember that? Did he include the travel expenses? Because the answer is yes, he did. And again, that's why I kind of think the answer is going to end up being the defense did not pay this $23,000, but I don't know the answer. If they did, it's a problem. Now, if they paid it with case number 2, because now they had to hire them as experts, whatever, no big deal, because the defense turned it over. So it's literally no big deal. All right, here we go.
Now you're.
Yes, you
Thank
can
you.
move on.
You've been qualified in other courts to testify as an expert in the area of accident reconstruction. Is that right?
Yes, sir.
And I'm going to pause it because each of these points is important. He didn't say 20 times. He didn't say 18. He didn't say 20. He just said, you've been an expert before. And he said, yes.
You were not hired by the defense in this case, correct?
That is correct.
At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met.
That's correct.
You did not who I
So first off, he said, you were not hired by the defense. That does not mean they didn't pay you anything, right? Just because you weren't hired by the defense is not the same thing as you didn't pay for anything. Additionally, he said, at the time you did your report. So that's not quotes. That's a parenthetical maybe. That is going to apply to the questions he's going to ask now. At the time you did your report. Let's remember that.
Oh, no, you did not know who I was?
I did not.
You'd never met Ms. Little?
No.
Mr. Unetti?
No.
Matter of fact, you'd never heard of this case.
That's correct.
You were hired by another agency not connected in any way to the defense, is that right?
Correct.
And not connected in any way to the Commonwealth, is that right?
Correct.
So your analysis and your conclusions and your opinions are completely independent of the defense and the Commonwealth in this case, is that right?
Objection.
Sustained. Mr. Jackson, you can ask it differently.
When you did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct?
Correct.
That report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right?
Correct.
The defense didn't have anything to do with that, correct?
Correct.
You'd never met us, didn't know who we were when you did this.
Correct.
You'd never met Mr. Lally, didn't know who he was when you did this.
Correct.
So your analysis, opinions, testing, and conclusions were requested by a completely separate agency.
That is correct.
Goes without saying, but I'm gonna ask it anyway. You haven't been paid by the defense?
You have not paid us anything, no.
Up until that question, I was actually starting to sweat a little bit, if you want my honest opinion. I was like, hold on a second, because I swear he said you haven't been paid by anything by the defense, because all that stuff, you were not hired, you do not work for, you didn't do the report for, all of those are okay. If you paid the travel expenses, but you asked those questions in front of the jury, that's okay. But you have not been paid anything by the defense. Now, here's a new gray area, right? The new gray area is, at this time, when he's sitting there at trial, had they paid those travel expenses? And if the answer is no, that they did not pay the travel expenses at this time, then that could still be a true statement. Now, I didn't go pull every clip of everything Alan Jackson ever said, from interviews to the courthouse steps. Amy said not paid yet, could be said. But I feel like I've heard him say it 1,000 times that they didn't pay Arca anything. But if the point is, at the time he said this, that was true, and now they have paid $23,000 whatever dollars, then they have turned it over. It's part, the Commonwealth could not have asked it in the first trial. Okay. So there is no prejudice. If they didn't pay him at this point, the Commonwealth could not get up and say, didn't you pay $23,900 or whatever it was? Didn't they pay this for your travel and expenses? What did they put you up in a, nice hotel? They couldn't ask any of those questions because they had not in fact paid that money. Timing matters. Words matters. Yep. Sakshi said, what if it was paid after the trial? That absolutely matters. Sarah said, I think she's trying her best to be impartial, but I'm convinced Judge Cannoni despises Karen and Alan. I think Karen should have a new judge. Well, if only it were that easy. But I think she's trying to. I'll tell you where I think she misstepped at the end of when we get to the end of the hearing. I don't know if we're done with this. There's about another minute I want to listen to. There's another minute I want to listen to of the back and forth between Jackson and Wolf at the first trial.
And you don't work for us.
That's correct.
As a matter of fact, I've never asked you specific questions about your testing before today.
That is correct.
He didn't say we've never spoken before today, right? At the time of your report, you didn't know who I was. We had never met, never spoken. Fine. But now the question is, and again, you can call it smart, you can call it slimy. My guess is the two sides of this case are going to have two different S words for what you call this and what people think of lawyers, right? They hate lawyers till they need one. That's how this channel started. The original intro, John O'Rourke will remember that, and probably agree with it. But he said, he changed. I never asked you specific questions about your testing.
Your work product, the report that you provided, was provided both to the defense as well as the Commonwealth. Is that right?
That's my understanding, yes.
And you were equally available to both sides?
In terms of them reaching out?
Correct.
Yes.
And I called you ultimately after receiving your report, asked if you'd join us and testify, correct?
That is correct.
All right. Were you and your team asked to undertake a review for purposes of accident reconstruction of the case that's now pending before the court?
Yes, sir.
Was your team asked to do this by the agency that ultimately retained you, not us?
That's correct.
Who at ARCA was assigned to the team who would ultimately undertake this job of accident reconstruction?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
What was Dr. Rentschler's role in this case as it's distinguished from your role in the case?
Certainly. So Dr. Rentschler is a biomechanical engineer, and ultimately he assessed whether or not there was a mechanism for the injuries of Mr. John O'Keefe.
And what was your focus? If he's talking about the injuries to Mr. O'Keefe, what was your focus in your reconstruction and your analysis?
All right, that's where we can basically stop it. We don't need to get into his testimony. Angela said, what if questions were between voir dire and testimony, then defense turned it over, but Brennan ignored it because Lally did ask what Crash Daddy said or asked Alan in the email. I'm not sure. I'd have to go back and really watch it a lot closer. Gringa said, why can't Jackson say FBI? I've never understood that. It's because it would be prejudicial and it does not necessarily prove or disprove a material fact in the case. Now, I get that all of us are like, well, it is a huge difference. And I mean, I'll be the first to say what a big deal it is that the FBI or the experts hired by the FBI actually produced this information. And frankly, that's why I don't understand why the Commonwealth even is continue going forward with this case, but that does matter. That does matter, that it would definitely have a prejudicial effect to the Commonwealth. And what does it actually prove in Karen Reed's case? I know what you guys are going to say it proves, but that's how the court looks at it. Why wouldn't she allow Alan a chance to be heard? Again, you're going to hate me for this. Oh, Turtle Boy, I see we have a question starred by him, so maybe he'll hate me for this. I think Judge Cannoni was trying to do the right thing to allow Jackson and everybody else to go back, get their ducks in a row, because now we have a much bigger issue on our hand, and she wanted to allow him time to respond. I don't love that. I wouldn't want that if I was the lawyer. If you want my honest opinion, I'd like to hash out as much of it as we can now, because that is the big issue here. That is the big issue here. And John Scott said, invoice is the biggest issue to me. Now need the invoice date, but without response from defense yet. All I have is questions. Exactly. We need to pause and withhold any final judgments until the defense responds, because how many times in this case, both sides, does the other side say, they only gave you half the truth, let me fill in the dots? So let's hear what the defense actually has to say about this stuff. It could all be hogwash. It could all not be exactly as it seems right now. Turtle Boy said being paid and being reimbursed for expenses are totally different things. Here's what I will tell you. I'm just going by, in my opinion, what I believe the rules say about disclosures. And if you pay for expenses for experts, you need to disclose that. And the other side can ask questions about that to show bias, because, and I will just say, there have been some lawyers that are not so ethical and experts that are not so ethical, where the expenses get really high in lieu of no expert fees to make it seem like you're not paying them, but you are, so that lawyers, and I have done this, can say $30,000 in expenses they paid you. You're allowed to ask those questions just like that. And if the jury says, I don't know if I can hold this expert as being very credible because of the amount of money they were given, and absolutely the defense can say, but you didn't have any fees, this was just expenses. And absolutely that can be something that the defense comes back out and says, they're not biased, these are just expenses. Rebecca said, and Alan Jackson isn't stupid. Not stupid, but probably choosing his words carefully. And again, feel free to disagree with me, as I'm sure a lot of you will, with how I look at, if you pay $23,900 in expenses, I think that is and should always be discoverable. Duncan said, do you not see a problem with the clearly uneven scrutiny with the defense versus the Commonwealth? Like, now she's gravely concerned, only just now seems like bias. I do see some of that. I hate it. I think it should be treated equally. Actually, I think, frankly, the defense should be given more credence than the prosecution, but I am going to call it even for both sides. And I have the whole time. I've said the Commonwealth has screwed up plenty. All right. Bev shakes in anger over potential defense violation. However, cool as a cucumber over Brady violations, failure to preserve evidence after trial, misleading evidence, pound rocks Bev. I don't understand how he can cry about a Rule 14 violation then when the deadline hasn't passed. Well, if they haven't turned it over for months and months, the defense has done the same thing with certain things, right? It's like, I asked you for this, you never turned it over. Now you're turning it over late. You're making things more difficult. This goes to, can they complain about it? Sure, but it's not going to get struck and it's not overly prejudicial. So it's like they can complain about it, but just like what you're saying, it's not going to, the sanction, in my opinion, is not going to be that they're going to, remove the ARCA experts over this personally, just personally. Okay. We are back to Brennan, I think, for another minute or two before we get after Judge Cannone leaves. Just kidding. I should probably put it on the screen.
$23,925. That's not trample. That's not trial by ambush. That's getting duped. So I didn't know any of this, but I've tried a few cases. I've been around the federal court a little bit. I know how it works. And sometimes parties pick sides. It creates an imbalance and unfairness, and then it allows the ability to one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation and this person, and then this happens. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions, but I care that it's unfair, imbalanced, and hidden. And the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
All right, I'm going to take a recess.
And did you hear what he just said? First off, that was definitely his kind of swan song. And that's how you absolutely know he thought this was all from the feds, because he's like, this is trial by ambush, et cetera, et cetera. It's like, well, then you say the defense gave it to you, because he just said at the very end, which let's play it one more time.
Produce the Commonwealth, like the defense, is entitled to discovery. So if they can produce the discovery, I'd welcome ARCA.
If they can produce the discovery, then I would welcome ARCA. That answers your question right there about whether late discovery should strike these witnesses, because it absolutely should not. By Hank Brennan's own words, if they can produce the discovery, so turn it all over now. Payments, whatever it is, he said, Judge, he admitted no prejudice right there. Turn it all over and let's go. Let's ride. That was one of the biggest lines of the entire hearing, in my opinion. If they can produce the discovery, we welcome ARCA. So produce what you got, which it seems like that's exactly what the defense did, since in fact, the defense turned that stuff over, which again, all of this leads me to believe Hank Brennan fully believed that was from the feds, and his argument crumbles when he comes back because he admitted if they produce the discovery, we welcome ARCA. All right. So the judge leaves for like 30 minutes and then comes back, and Hank Brennan provides some clarification for the court, we'll call it. Let's answer a couple questions. Why would the defense hide it in trial 1 and then just hand it over in trial 2? Why not just keep hiding it? I don't think the defense lied. I tend to agree. I also saw a bunch of posts like this, that there's a purchase order. DOJ paid the exact amount of the bill to ARCA on June of 2024. I think it would be kind of hilarious, not hilarious, because again, this is very serious. And if she loses her lead defense attorney, totally unfair, shouldn't happen. But that would be the absolute worst egg on Hank Brennan's face ever if it turns out that this was paid by the DOJ. Then he has basically nothing to hang his hat on, especially because he said, if they produce the discovery, we welcome ARCA. They're not afraid. Don't you have to do billing even if pro bono? So everybody does a little bit differently. Some pro bono writes off the costs. Sometimes you can bill for it. I'm just telling you how lawyers usually are and how I always am. I would always disclose anything they ever paid to an expert because this is just not worth it. Peter, can you explain how mentioning FBI equals overly prejudicial? Of course, it's a bad fact for them, but the probative value seems higher. That would be like, let me switch it because I think you'll be able to see it. That would be like in another case, them saying, every cop thinks the defendant's guilty. Every cop in our station thinks the defendant's guilty. Doesn't actually prove anything, would be prejudicial, might be true, right? In this case, saying that the FBI hired them, the judge found, and I think there are arguments on both sides of this, by the way, just so you know. I think there are arguments on both sides, but I think the judge found that the fact that the FBI hired these experts, which you tell me what fact in the Karen Reed case does it prove or disprove? What material fact? Bolstering the expert witness is not a material fact of the case. Okay? That's just my opinion on how I think the court came down. Could they pay the FBI directly and have it not discoverable? Oh, no, the FBI would not be down for that. Rebecca, how do we not know what the FBI was paid by the DOJ to look into the law enforcement in this case and how it was handled? We really don't know why they were involved. I mean, we don't know a ton about the federal investigation. You're absolutely right about that. Absolutely right about that. John, predictions for best and worst case scenario for both sides. I have an issue with the invoice, but how big of a deal is this in reality? Seems like everyone is overreacting. In my opinion, if I was the judge, I would say, defense, you have to turn over everything you have with ARCA. And if we find out later that you didn't turn over everything right now that you have, you will be sanctioned and thrown off this case, potentially fined, et cetera, lay the hammer down as much as possible. Order them to do it. That's what I would say. That worst case scenario is she finds an intentional discovery violation and fraud on the court by Jackson, throws him off the case, sanctions him, strikes the ARCA experts. Sure. That's worst case scenario for Karen Reed. I don't expect that to happen. I really don't expect that to happen. All right, here we go.
All right. So the Commonwealth just provided the court with information that causes me grave concern. The implications of that information may have profound effects on this defense and defense counsel.
So that is giving you the indication that she's either going to sanction him personally, make him pay some kind of monetary amount, or throw him off the case. That's what that sounds like if I was going to try to read between the lines of a judge's words.
So for that reason, I'm going to suspend today so that when we meet again to address these issues, all affected will be appropriately prepared. So I'll see you a week from today at 11 o'clock in the morning. You can tell me now if that is impossible for you.
My opinion, with this case, with the coming trial date, with all the lawyers involved, with the defendant's, life hanging in the balance, I don't think there was a reason to push it. I think you give the defense a chance to respond. We're lawyers. This motion has been filed, and we continue on and let them argue. And if they ask you for a week because we need to go get things, or you have questions that they cannot answer, they ask you for a week. In my opinion, there was absolutely no reason to end this hearing today. We're going to listen to Hank give his little timeline and what the lawyers say at the end. But I disagree with the short continuance. I think you should have let him respond and argue it today. And if they want to provide more documentation while you're taking it under advisement anyways, that's what should have happened, my opinion. I think this was an unnecessary delay.
Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there or check with whomever you were dealing with to see if I can in fact get a copy of everything that you just read?
I can, and there's a brief chronology I think Your Honor should be aware of. If I could add that right now, it would take me less than a minute. The chronology is December 4th, we sent another tour request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30th, 2025, the United States Attorney's Office sent a response to both ours and the defense requests. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether a party could engage. On February 11th, we filed the motion to exclude. February 13th, the defense provided us the emails that I read, February 13th.
That was like what's his name? Dave Chappelle. Gotcha. Not really, right? That's tough. But I will just tell you, I give him, you guys are going to hate this. I give him credit for standing up there, taking the gut punch that he was just completely wrong about his, smoking gun moment, his Matlock moment. He was just completely wrong about it. He got up there, he corrected it. It should absolutely change the way everybody, including Judge Cannoni, looks at this. The fact that the defense turned it over and not the feds.
13, 2025. I think the defense provided us the emails that I read, February 13, 2025. I think I said the federal government. It was the defense. February 13, 2025, they sent us the emails and the direct examination outline. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract has ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we've refrained and we will not reach out to them.
All right, so the information that was provided to you, not from the federal government, I'd like a copy of before you leave.
The judge was like, okay, then what was given you by not the feds, aka the defense, who turned it over in discovery? Wouldn't be the first time late discovery was given in this case, right?
Before you leave the courthouse today.
Yes, Your Honor.
All right, 11 o'clock a week from today.
Your Honor, is it possible to move it one day to the 26th instead of the 25th?
That does not. it would have,
So they talk about scheduling. It ends up on the 25th, but I did want to get Yannetti's comment just to kind of make my point about how annoying and frustrating this would be as part of the defense team.
so we'll see everyone.
I'm sorry. Just on behalf of Mr. Alessi, is there any chance the court would entertain the motion that he's doing today or no?
No.
Okay.
And he sits right back down. It's like, no. It's like, why not? Okay, so let's say worst case scenario, you're going to kick Jackson off the defense team. Why can we not still handle the motion that we're ready for today, that all of us defense attorneys, everybody from the Commonwealth, everybody from the public, Karen Reed, we're all sitting here. We have the time. It's so hard to get time with all of our busy schedules. Why can't we just handle the motion that he's having? That's frustrating to me. And if it's because the judge needs to go calm down, that's supposed to be a quality of a judge. You're supposed to be able to deal with pressure and difficult decisions and stay calm, not let your emotions get the best of you. That's like literally category and characteristic number one for a judge, but not what happened here. Amanda said, do you think the feds found nothing and that's why there are no arrests, or are they waiting for trial too? Again, it would be a total guess. I have no idea. My guess would be, I don't think they found nothing. I'd be surprised if they found nothing, but the feds need a lot to indict and move forward. So maybe they just didn't feel like they had enough, or they're waiting. Said it before, I'll say it again. Thank you for always being impartial and teaching us from all sides. Christy, I'm not sure everybody agrees with that or appreciates that on this stream, but I appreciate you guys being here on both sides and asking me the questions, asking the hard questions, giving the details you remember and you think are important. I love it. I want to hear the details you say, but this was said, that was said. If it was said like this, that's important. I love it. I love that interaction. I know some of you guys hate it, but I appreciate it. And hit that like button if you guys appreciate it as well. Will the defense be able to mention how much the state is paying Hank to try the case? Seems relevant? No. I should say, I don't think so. I've actually never tried a case against a special prosecutor. I don't think so. I would be shocked if they were, just like they're not allowed to say how much a defendant paid their lawyer. And you also can't say the prosecutor's salary. To me, because the state has had so many issues, impropriety from top to bottom, and the defense, nothing that can come to mind, it unfairly magnifies this potential violation. Bev knows this. A crazy sanction here by the judge would, I think, set this entire thing on fire. We'd have appeals going up to the higher courts. They'd ask for her to get removed. I mean, it would set a lot into motion. Is it me or does Jackson not look that worried? I kind of agreed. But I saw some other people in the chat saying he's red-faced. He looks really nervous. I felt like they look not bothered one bit, personally. That was my take from it. Can she not allow Bederow to join the team? Well, with that question, let's hop to that section here. And they discuss the Pro Hoc Vice motion, getting Bederow in. And the defense doesn't really have a lot of argument. The judge says, just like your last motion, it didn't provide enough detail about what the good cause is and why you need it. And so can you just provide me an affidavit with more information? And then I will likely grant it. That's what she said. Once you do that, I will likely grant it. And then Hank Brennan steps up and he's like, I don't want to object to her lawyer, but that's exactly what I'm going to do. And here's the spiel he gave. I am going to speed it up a bit.
Okay. The next one's paper.
Maybe her brief.
Yes.
Maybe her brief.
Yes.
The court, and everybody thought we were moving on, but Brennan's like, oh, no, hold on a second.
Opposition.
It's not an opposition, but I have some thoughts that I want to share with the court.
Okay.
It's not an opposition, but it is an opposition.
It's not an opposition because I think a defendant who's presumed innocent has the right to counsel of their choosing. I think it's a very fundamental right. And I don't think the Commonwealth should dabble in taking a position trying to prevent an accused from having counsel of their choice. That being said, as Your Honor may be aware, Mr. Bederow is also an attorney for Mr. Kearney. And that is something that I think the court should consider and be thoughtful about for a couple of reasons. There is a history, a symbiotic relationship between Ms. Reed and Mr. Kearney. There is a history of documented evidence showing the sharing of discovery between the parties. And inevitably, that discovery is promoted in such a way that abuses, harasses, and bullies witnesses in this case. Not unmindful that there's over a dozen indictments against Mr. Kearney, which Mr. Bederow is representing him for. Now, it's not great clarity, but it's been represented that there is a relationship between Mr. Bederow, Mr. Bredel, who's Mr. Kearney's other attorney, and the defense attorneys in this case. There's a record that has been represented that the attorneys in Mr. Kearney's case, Mr. Bederow, Mr. Bredel, have an understanding with the defense attorneys in this case, that there's an ongoing long-term implicit mutual assistance and mutual defense that they've been a part of for a long time. Now, the Commonwealth is not entitled to any product of a mutual defense, but it is curious in that Ms. Reed and Mr. Kearney are not co-defendants. It is curious that given the indictments, most of them that deal with witnesses in this case that allegedly have been harassed and intimidated, it is curious that that relationship exists and the nature of that relationship. It's not something that I think I'm entitled to, but the court certainly could delve into that ex parte. It's important because we'll later talk about in a sanctions motion, a violation, a direct violation of protective orders in this case.
All right, so let me break a couple things down for you guys. Peter, who's this guy he's talking about? So Bederow is a lawyer who came on our podcast. He's been on other shows talking about this case. He talks about it on Twitter. He represents Aiden Kearney. Some people are saying, who's Aiden Kearney? That's Turtle Boy for witness intimidation regarding this case. And he already represents Kearney. Now he's trying to pro hoc in to represent Karen Reed. And while Hank Brennan doesn't have an objection, it seems like he has an objection and he doesn't want Bederow to be able to pro hoc in and do that. As long as they have a conflict waiver and there's no real issue there, I still don't think this is going to be enough to stop him from pro hocing in. But what will Judge Cannone do? I don't know. Could the judge's behavior be brought up on appeal? Yes, absolutely. It's pretty much like the number one thing brought up on appeals. Could it be something totally different the judge learned in an ex parte meeting, or else I would be shocked, especially with how she phrased it, like what the Commonwealth just brought to my attention. Given the importance, would you begin a question with, when you were hired by the FBI, risking Shanks? Absolutely not. No, I would never, ever risk something like that with a question. It's just not worth it. It's just not worth it to do that and violate court orders and be unethical. Nitsa May. Peter, if you were Alan Jackson, would you have asked to address Brennan's argument on the spot? I don't know. It's impossible for me to know what he knows and what he has at his fingertips. But usually lawyers like more time to prepare. So if your neck is on the line, probably you want more time to prepare.
And the discovery in this case was provided to special attorney in Mr. Kearney's case to make sure that there was a thorough review of all discovery. And much of that was turned over subject to protective order. And I expect there'll be a similar motion in Mr. Kearney's case. Within 24 hours of the violation in this case, there was a violation of different material in that case. And so inevitably, you have Attorney Bederow who will be serving two masters. He will receive protected information in this case that is supposed to remain protected and not leaked and distributed to the media and the press and court pleadings. And some of that information will not be information that Mr. Kearney is entitled to. And being in a position of representing two different defendants who are not co-defendants, being in that position is going to be a difficult task to manage. And I am worried, and I have good reason to be worried about the privacy of our protected material. I have good reason to be concerned about the improper dissemination of our material. I have a reason to be concerned about the continued harassment and bullying of witnesses. And this information, if a court order won't protect it, then nothing will. Then nothing will. And so we know this relationship is substantive. We know it is a deep relationship. The attorneys.
So basically, he does not think Bederow should be allowed to come in pro hoc vice and represent Karen Reed because of the relationship with Turtle Boy. That's not necessarily enough to strike him, but Judge Cannone will have to weigh the options and make a decision whether or not she is going to allow it. Okay, let's jump a little bit earlier in the hearing when Hank Brennan discusses the fact that he no longer trusts the defense attorneys and why and what he's going to do about it and how all this is a, smoke and mirrors and distractors, basically. Let's take a listen here. There's two more clips I want to play from this hearing. I really want to listen to Eliza Little's explanation of why they need the Sandra Birchmore information and material. That is incredibly important to me. Her explanation as to why sheds a lot of light on some questions we had before.
So to talk about reality, the reality is that I invited them to come. It seems like another effort to portray some type of injustice brought upon the defense that half the facts are left out of the presentation. So to talk about reality, the reality is that I invited them to come download the DVR, NVR, where they full well knew that I had no idea if there was still video on there, and why would they be 3 years later? And after they filed a motion making representations that weren't accurate, I no longer have the confidence to have off-the-record agreements with the defense.
And that's happened before in cases. It's not great when it does happen, but it does happen. It's definitely not the first case that's ever happened. Cooper said, isn't it somewhat unethical for her to suspend without hearing from the defense first? She made judgment based on Commonwealth argument without letting defense argue. She didn't make a judgment. She didn't make her decision. It would absolutely be wrong if she made a decision without letting the defense argue. But continuing it is within her discretion. To me, it's just like not great by her. But I wouldn't say it's unethical. I just think it's kind of like unnecessary is what I would say, not unethical. Netwoman, dumb question. Doubt it. Couldn't the FBI be involved because a police officer was killed at a place where more police officers were at where a house party was going on? The optics look bad at a different agency like the FBI. Thanks for the fabulous coverage. I would say my answer to your question would be yes, it could be. It just does not seem like that's the case here. It seems like they are investigating the investigation because of what's going on in the investigation. That's my guess, but we don't really know because we haven't seen the federal investigation and all the documents and everything that they have at this point.
There has to be a certain level of confidence that when you have an agreement and you try to help the other side, that the memory of the discussion is going to be portrayed accurately. And in losing confidence, the best way to practice for discovery is motion. And yet the court asked me to meet with the defense after court, and I will always honor the court's request. So because of your order, we met with the defense. Now, as a matter of background, when they came out to look at the DVR, there was no motion. That was by invitation. It wasn't lip service. It wasn't trying to spin a story for the media. It was a good faith effort to accommodate the defense to an entitlement that they weren't actually entitled to. I didn't go on the 12th and speak to the police officers because we were here on Dr. Russell. I went after because I wanted to know more.
Generally, this argument ends with Hank Brennan saying, we'll turn everything over to you. This should be simple. The defense is like, yes, send us the metadata. That's what we want. And it should be simple. You're right. Then they get into the Rule 14, inspecting the car. Brennan's going to give them a 3D scan. They all seem to be on the same page with that. Reciprocal discovery, they don't want to turn over impeachment. They basically reiterated what was in their motion. Brennan said this can't be a trial by ambush. They need to turn it over. The judge is going to issue her order later. And then we get to the compelled discovery by the defense. That's going to include the Birchmore information and more. But I wanted to hear the defense's actual explanation as to why they need that. She kind of discusses the different sections of their motion to compel. And we'll take a listen to her and what she has to say there. Hank has implied misconduct by Bederow sharing info. Can Bederow do something about that? Love your channel, Peter. I agree. I do think he almost did more than imply some nefarious backdoor information happening. And I mean, Bederow, what he can do is come and argue himself in court and say, Judge, I want to set the record straight because he, besmirched me in court. And I think he should have the opportunity to do that. Absolutely.
To create a document if that's not already in existence?
And by the way, Brennan said multiple times the defendant should have the right to pick her lawyer. He's right. And that really is the most important right there, not the other things.
That information is in their possession. It's Brady, right? We have Canton police officers who handled this footage. We have Massachusetts state police officers who handled this footage. They know that they downloaded the information. You cannot skirt your Brady obligations by failing to memorialize things in reports. We are asking for basic reports from the witnesses who recovered this evidence. They can't avoid cross-examination on evidence that they're admitting at trial by failing to disclose who obtained it and when.
She gets a little, she gets after it here with this argument when she's like, they can't skirt their obligations by just saying it doesn't exist or just not doing something.
And I can understand why they might not want to do that. There's an ongoing federal investigation. No one seems to want to take ownership of these videos.
Yikes. She's like, no one wants to say they're the ones that gathered or kept the videos. It's like, I get it. The feds are investigating.
But that does not absolve them of their Rule 14 obligations. We still don't know who the custodian of records is.
You see Alessi is writing notes on his iPad and showing them to her while she's arguing. That's kind of cool. That's what's awesome about having a huge defense team like this.
We still don't know who the custodian of records is. The Commonwealth cannot skirt its mandatory discovery obligations by refusing to memorialize this material and relevant evidence in a report simply because they don't want the individuals involved to be questioned about it. The Commonwealth is intentionally subverting its obligations under Rule 14. We're asking that this request be allowed.
All right.
The second category of information, Your Honor, is information that relates to the Norfolk County District Attorney's Office investigation clearing Officer Matthew Farwell of the murder of Sandra Birchmore. There are certain names that this court will recognize. First responding officer, Sergeant Lank. Detective, Kevin Albert. Trooper, Mike Dunn. Trooper, Zach Clark. Colleen Crawford. Lieutenant John Fanning. Trooper, Garino. Lieutenant Brian Tully. Trooper, Kathleen Prince. And Norfolk County District Attorney, Michael Morrissey. All of these individuals are material and relevant witnesses in this case. They are also material and relevant witnesses in the investigation that cleared sworn peace officer Matthew Farwell in the murder of Sandra Birchmore. The parallels in these two cases could not be clearer.
And that's the important part, is the parallels in these two cases. Sweetie Sue said, did Bev's meltdown occur during the Commonwealth motion for sanctions against the defense or during the Commonwealth to exclude ARCA? Could there be another sanction? I think it was definitely the ARCA exclusion, because Yannetti wanted to argue with the sanctions one. She was keeping them separate, but it seemed like they started to kind of come together. So we'll see. Nina said, in Switzerland, they keep you in jail for 2 years before they even indict you. Your system isn't perfect, but way more transparent than every EU court. So I'm not an EU court expert, but I would agree that everything I've ever studied, our system is the best and the most fair, but it's far from perfect. Lori, Peter, when the lawyer in a case becomes a distraction to the case, that isn't it right that they resign on their own? Lawyers who are a distraction would worry me if I was on trial. So what it really comes down to, I don't really care what anybody else in the world says. And most lawyers like this, it's you and your client. What do you and your client say? Do they think you're a distraction to the point that you can't effectively represent them? Who cares what the media says? Who cares what a YouTuber says, right? Who cares what I say about anything on this channel to an attorney-client relationship? That is between them. And if there is trust and confidence, that's what you need. Peter, how likely do you think it is the feds are delaying action until after Reed's case is over so as not to affect it? So this is a very common question from my perspective. I don't think that's what's happening. If they really thought that there was a corruption here and cover up, I don't think they would wait to see if she gets convicted and just let an injustice happen. I think they either don't have enough or they're just trying to gather more, or they already know they just don't have enough to go forward and they've kind of made that decision. Peter, do you think AJ will bring his own attorney next week? I don't know. Maybe one of these guys will represent him, or gals. I would think maybe Eliza. I think she's the one that's in his firm, right? AKA Shishi. Can Brennan tell the jury that ARCA presented the defense a bill and talk something about Austin's to ask? They can absolutely talk about if they paid them, right? To say they submitted a bill that wasn't paid, I don't think the prosecutor would do that, because then it looks even more unbiased. If they're like, oh, $23,000, yeah, but we didn't even make them pay it. So I don't think they would ask unless it's paid.
It's the same material witnesses, same investigators, same prosecutors, same failure to investigate a law enforcement officer who should have been a suspect. Specifically in terms of our requests.
So basically very similar to what my dad and I thought. Those parallels, covering up for a law enforcement officer, bad investigation, those are the parallels. And that's what they want to compare.
We've requested an unredacted copy of MSP report number 26. There are certain reports in this case, Your Honor, that deal with material witnesses that are so heavily redacted that we can't make sense of what is even in them. It deals with an interview conducted by two material witnesses in our case, Lieutenant Fanning and Trooper Kathleen Prince, and we're simply asking for an unredacted copy of that report. As to request 3, we're asking for an unredacted copy of public record responses regarding email correspondence and communications associated with the Sandra Birchmore investigation. The communications we've received in our case have been revelatory, material, and exculpatory. Given the consistency and parallel type of investigation, the communications between and among law enforcement officers and the Norfolk County DA's office with witnesses who are material to our case are relevant and should be turned over in discovery. Finally, we've also asked for an unredacted copy of all reports, communications, and handwritten notes and other documents from the Sandra Birchmore investigation concerning material law enforcement witnesses in our case. Your Honor, the reports by investigating officers that led to the improper clearing of Peace Officer Matthew Farwell in the Birchmore case go directly to the credibility of those law enforcement officers and their reports. The reports that they drafted in reaching certain conclusions, clearing Officer Farwell, directly go to their credibility in our case, which again, deals with the clearing of a fellow officer. And I would cite one example, Your Honor. For example, Massachusetts State Police Trooper Garino, the same person who obtained and analyzed the electronic devices in our case and reached certain opinions and conclusions, also analyzed electronic data in the Birchmore investigation. As it turns out, Trooper Garino made certain ultimate conclusions in at least one of his reports, stating that Really, there's nothing to see here. I found some text messages. They corroborate that Matthew Farwell had a consensual relationship with Sandra Birchmore. No evidence of improper conduct, nothing to see here. Yet, when the federal investigators looked at the electronic data, they recovered tens of thousands of text messages between Birchmore and Farwell that implicated Farwell in her murder.
And that is like woof, right? That is woof.
The text messages, which are publicly available and referenced in federal search warrants, affidavits, are incredibly disturbing. They establish that he had sex with her as a minor when she was in a cadet in the Stoughton Explorers program. They detail violent fantasies. It's clearly implicates Matthew Farwell. It's not even a close call. Is it relevant and material to us that the same expert would analyze a fellow officer's electronic devices and make those types of conclusions? Of course it is. This information goes directly to Garino's credibility, bias, competency, and ability to conduct an investigation in this case, where there were law enforcement officers who should have been suspects.
I 100% agree that some of that stuff should be relevant. They're just not going to be able to get into the details and facts of the Sandra Birchmore case. It's going to be an officer was a suspect or something like that. They're going to have to pacify it, just like the FBI hiring these people.
As to request number 5, Your Honor, we're asking for documents related to the internal affairs investigation into Trooper Michael Proctor. As the court knows, we have an ongoing Rule 17 motion as well with regard to these documents. The Massachusetts State Police is an agent of the Commonwealth. The internal affairs investigation happened quite recently. We're asking the court to go ahead and order those documents because we are on the eve of trial. The administrative hearing that took place deals directly with allegations of misconduct by Trooper Proctor in this case. If Attorney Brennan's position is that these documents are not in the Commonwealth's possession, we're asking the court to go ahead and just order that information be produced so that we're not having to scramble on the eve of trial to obtain that
So if
information.
it's Rule 17 instead of Rule 14, the third party has to be served, right?
So there is an ongoing order, Your Honor, under Rule 17 as well. We already filed that, a Weenus motion back in 2022, and it was ongoing.
All right. If somebody can tell us the paper number so we can find that.
Thank you, Your Honor. I will. The Commonwealth has indicated that they do not object to requests 6 and 7, so we'd ask that the court allow those requests. As to requests 8 and 9, those deal with a request for communications between the Norfolk County District Attorney's Office and its law enforcement agents on the one hand, and all experts retained by the Commonwealth in connection with this case. We find the Commonwealth's response to this request objecting to it particularly interesting. They claim the request is overbroad, that it is beyond the scope of Massachusetts Rule of Criminal Procedure 14. And the reason it's interesting that they're objecting to this request is because our discovery request is copied verbatim from Attorney Brennan's request as to the ARCA experts.
That's kind of funny. Karen Reed like that too. I heard the judge said something to her for smirking, but I didn't actually hear it happen on the video. But Brennan explains that it's different when you're asking for the ARCA stuff versus what they're asking for. But
now that he's on the receiving end of that request, he's objecting to it. All we're asking for are the material and relevant communications that the Commonwealth and its agents have had with their experts in preparation for this case. Ms. Reed is entitled to that, and it's proper in terms of being able to effectively cross-examine those experts. And as to request 10, Your Honor, there's no objection. We'd ask that that be allowed.
It's important to represent facts accurately. And the court
it really starts every single one with that. It's important to state facts accurately. Brooke Smith, I literally had this exact thought today. Well, any of these cases, am I the crazy one for not having all this stuff in my trials? Like, that's what I'm starting to think. Is it's like we've had like pieces of it or aspects. Like we've had this one thing happen with this one expert or this one lawyer or this one judge, to have all of it happening in one case. And it seems like it's everywhere, like it's spreading, like it's some kind of, like it's contagious.
has ordered in the past when representations have been made that they be accurate. We hear an echoing of a claim of Brady, but we hear no substance behind that claim from the defense as to, number one, the Commonwealth is not going to make logs up that don't exist. They're not going to make a record of something that is not in writing, that there is no witness for. The defense has asked for chain of custody, logs, evidence, reports. If they existed, they would get them. I told the defense in an informal discovery request I would look into any chain of custody information, and I did. I've spoken to a number of witnesses, including the retired sergeant And I expect that I will have him write a report to give to the defense, and I'll provide them all the information that I have about what I could find out about the tapes that were provided in this case, where they came from, who downloaded them, who touched them, and who they went to. But there are some things the Commonwealth cannot do. They cannot simply invent a log when a log does not exist, and they cannot invent a chain of custody that is not in writing and there is no witness to. I've done my best to be thorough and diligent, and they will receive a report and have all the information that we have.
He says that a lot. I'm going to give you everything we have. And that's good. And he should. But is he? Albie, why was she saying Jackson could zoom in next week if she was considering removing him or ARCA? Seems like something too important for a Zoom call. I agree. It's like she's so mad this day that everybody cleared, so he's not going to have the opportunity to be there in person. I mean, Zoom is pretty great, but if he wants to be there in person, he should absolutely have the opportunity, and Karen Reed has the right to have him there in person. I agreed with you. I had the same thought. It's a great point. Jenna was waiting for this to start, and 19,000 or 196,000 things happened. Now I'm super late. Well, I'm glad you're here. And what's awesome about YouTube is you can still go back. It would have been awesome to have you here live the whole time, but you're not going to miss anything because you can go back and be part of the rewatch crew. Just make sure you hit that like button.
Odd that it's important during argument to mention that there's an ongoing federal investigation and then list a number of witnesses for the Commonwealth, implying somehow something's nefarious, that these witnesses are involved in this other controversial case that has nothing to do with this case that the defense would like to parasite onto. And so they just throw out terms and words for our audience that's here on our right to try to create an illusion of impropriety. There is
Our audience is here on our right, an illusion of impropriety.
nothing that they have provided about the Birchmore case that will provide a basis for the Commonwealth to now go scramble and search for information that there's no good faith actually exists. It's easy to throw out a name and attach it to the Birchmore case, troopers, the DA, malign their name the way they know how to do. But when you're arguing a discovery motion, there must be a factual basis for it, a factual basis, a good faith basis. We hear the defense say that Trooper Garino says, nothing to see here. I have not seen that report where Trooper Garino says nothing to see here. I don't know what report they're speaking about when they suggest Trooper Garino had done something wrong in a different case. They imply it. They're suggesting that's the basis for you to compel discovery on a case that has nothing to do with Ms. Reed's case. They just say it. And so you should reject outright an argument that tries to imply impropriety when there is none, with no factual basis or good faith basis, because they want to entertain our audience. And so the reality is the Birchmore case is being investigated by federal authorities. There's been a number of disclosures by the Commonwealth for information that has been public record. And there is no good faith basis that there is something in that case that is relevant in any way to this case. Ms. Birchmore was a victim. Number 4, unredacted copy of all reports, communication, handwritten law enforcement notes, again, in the Birchmore case. Why? Why that case? Troopers work on many cases. That case certainly has a public appeal to it because of the harshness of it, the sadness of it. But what does it have to do with this case? Nothing. But invoking it
Is it nothing or is it not? Because that's really what the judge has to determine. Is there a connection? Is there a similar method of operation investigation where they should be able to get into it or not? That is the $1 million question that's going to determine whether or not anything is discoverable from that.
is helpful for the defense. So they do. You should reject it outright, Your Honor. Number 5, all communications, documents, reports, memorandum regarding Trooper Proctor administrative proceedings. Any information in the Commonwealth's possession and control, we would and we do turn over. In addition to what's in our possession and control, we know that there's likely statements that would be helpful for the defense. So we have an affirmative obligation under Graham. In fact, I had a conversation with defense counsel, and they asked if I would join them in a phone call and speak to counsel for the state police to try to encourage the production of materials in this case, whether they're exculpatory or not, even material irrelevant. And I agreed I would do that upon request. Now, that call has not been set up by the defense, but when it is, if it is, I will be there and I'll advocate for them for this information. In addition, there's a Rule 17 that has been ordered by this court that imposes an ongoing duty separately upon the state police. Now, state police have certain protection where it's an internal affair investigation by law. I cannot usurp that law. I can only earnestly try to my best of my ability. I sent the email on January 28, 2000.
All right. So that's the basic gist on the Birchmore and Proctor situation. So a lot happening, and it's all continued until next Tuesday, February 25th, where we will be covering it again. So that's it, folks. That's all we got for today's episode. Another hour and a half episode. They're seemingly getting longer and longer with all the stuff going on, but I'm glad you guys came to hang out. I appreciate hitting that like button. I know people get annoyed sometimes when I say it, but I appreciate it. And it lets other people that want to watch and interact with this content, it gets it out there for them too. Hit that subscribe button and reminder bell if you guys want to keep coming back for more, because I love the discussion. That's what drives me. That's what gets me going. And I appreciate it. I want more of it. I want to continue being open, answering questions, discuss all this. Angela said the appeal has been filed in federal court. Figured that would happen. I'm not going to read all 700 pages. We'll see. Maybe we'll talk about it at some point. Been a while since I caught a live. Is 23,000 normal for flights, food, etc.? Thanks. Seems like a lot to me, but if it was multiple trips, I mean, it's possible. If they had to bring multiple people, equipment, things like that, we'll see. But we'll see what it actually ends up being. Okay, I got to get out of here. I appreciate you guys. Love hanging with you. Till next time. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.